Good afternoon. My name is Renee Castillo de la Cruz, and I'm a staff attorney at the Texas Children's Commission. On behalf of the Children's Commission, I would like to welcome you to today's webinar entitled Handling Your First Child Welfare Appeal. This presentation, provided by Michael Hull, Assistant County Attorney at the Harris County Attorney's Office Civil Appellate Division, and Karen J. Langsley of Langsley Mills Law, LLC, will focus on the basics of filing a child welfare appeal, including important deadlines, required notices, what to look for when reviewing a court record, key elements of the Texas Rules of Appellate Procedure, and rules for drafting a petition. A PDF copy of the PowerPoint presentation, along with any additional materials provided by the presenters, will be made available for download on the Texas Children's Commission On-Demand Training and MCLE webpage. For those watching this live presentation, a Q&A feature is available for this webinar, and questions will be addressed at the end of the presentation if time allows. Additionally, the MCLE course number will be provided at the end of the presentation. If you are watching the webcast replay, you may email cctraining@txcourts.gov for MCLE's self-reporting information. It is now my pleasure to turn this over to our co-presenters, Michael and Karen.
Thank you, Renee. This is Mike Hull. Karen, would you like to say something?
Hi, everybody. Good to see you again. So I got to say, having looked at this, having looked at your PowerPoint, it's really amazing. And so especially for those of you who are going to be doing your very first appeals, this is just an incredible resource. So thank you, Michael, for putting that together.
Thank you, Karen. Our first question is, whose job is it anyway? A few months ago, the Children's Commission had a webinar on, or provided a webinar that talked about this in much greater detail, and that too is available on the Commission's webpage. So we'll talk about this only very briefly. But in a suit brought by the government seeking termination or appointment as a conservator, the attorney appointed continues to serve as the ad litem in that capacity until the earliest of the suit is dismissed. All appeals in relation to any final order are exhausted or waived, or until you're relieved of duties by the trial court or replaced after a finding of good cause by the court on the record.
The biggest, most important thing about this is do not assume that once you get that judgment or rendition that you're done. You absolutely, if you're court-appointed counsel, your duty to your client is to stay on this until you find substitute appellate counsel, or you are going to have to get going really quickly if they want to appeal.
Yes. And once a parent is found indigent in the trial court, they generally remain indigent. So that's something in my office, we handle a lot of these appeals. We don't concern ourselves with because they're staying indigent.
Yep.
In re PM is an important case. If you're going to, well, I'll tell you what it establishes. It is the right of an indigent parent to appointed counsel in the trial court and the Court of Appeals comes from these particular statutes. The issue in PM was whether that also included a right to petition for review in front of the Supreme Court, and the court held it does. I think you'd agree with me, Karen. In most cases, it probably presents an obligation to petition for review.
Yep.
Particularly.
But here's my question about that, Michael, though. Let's say you get a termination judgment and your client has disappeared, or you do your appeal and it comes back not in your favor. You don't know where your client is. Do you go ahead and file the petition for review or PFR? What do you do?
Yeah, that's a really tough call. My view is you file it if you can't locate your client. And what I've seen done here in Harris County in one of the courts of appeals, I can't remember which one, the attorney then filed something with the Court of Appeals that says, I can't locate my client. I've made X, Y, and Z efforts, and I don't believe I should go forward with an appeal without direction from the client, either whether to go forward what they want, the court to review. And the Court of Appeals sent it back to the trial court for a hearing, and those findings were actually made by the trial court. How much effort was put involved to find the parents and that kind of thing. And the trial court made findings, sent it back to the Court of Appeals, and then the Court of Appeals dismissed the appeal. That seems like the reasonable way to go to protect yourself if you cannot locate a client.
Yeah.
Probably the best thing to do if they are at trial is ask them that day, the final day of trial, regardless of how this comes out, if you don't win, do you want to appeal? Don't wait, because that's a common complaint is can't find my client.
So speaking of timelines, how much time do we have?
We have 20 days, but let's not get ahead of ourselves, Karen.
Okay.
And
Be
withdrawal,
aware, people, be aware.
that's foreshadowing. Withdrawal is only permissible on a showing a good cause. Generally speaking, you don't like doing appeals, it's not good cause. Although in many counties and courts substitute appellate counsel pretty regularly, pretty routinely, so that's not really an issue. But if you're in a smaller county, you may be stuck with it. Trial counsel is responsible for filing until appellate counsel is appointed. And I would go a step further than that, say until appellate counsel is aware they've been appointed. Again, I've seen issues where the court will appoint an appellate counsel and nobody tells the appellate counsel and a deadline passes. And so if I were the trial counsel, until I actually, we actually have some, if you all review the 2024 Children's Commission Toolkit, just came out a few months ago. We've included a list in there of things that as trial counsel you probably ought to do, even if you're going to be replaced by appellate counsel. Like we said, the first thing you do, notify the client that there's a potential for appeal. If they're indigent, they won't have to pay for it. Explain to them what the deadlines are. File your motion to withdraw or for discharge, and request appointment of appellate counsel. Make sure you set a hearing on the motion if that's necessary, if your court doesn't do it automatically. And if I'm trial counsel, I'm filing the notice of appeal, I'm not waiting for appellate counsel. There's other duties that the appellate counsel will have to take care of that aren't jurisdictional. The notice of appeal, we'll get to that too. I'm getting ahead of myself. Out of an abundance of caution,
okay.
I would file the notice of appeal if the client wants me to file it. But once you get that order, I actually email and call the appellate counsel and say, you're it now. Here's a copy of the order. Here's the date the judgment was signed. And here's, your notice of appeal date. And then I would call the client and say, here's your appellate counsel. He's replacing me. Here's his contact information. And, if I'm trial counsel, I would document all this too, to make sure you're not the one getting the grievance if something goes wrong. Furthermore, if you're the, anything to add, Karen?
Oh, I was just going to say, so again, I cannot underscore this enough. 20 days after that final order of termination is signed, 20 days, you really need to get going. There's going to be a little, hey, wait until the 20th, close as you can to that 20th day, like calendar it for the 18th or 19th. And that's to respect the court reporters, but we'll go into that later.
Furthermore, children's ad litems may appeal if they wish to, and retained counsel, of course, can limit the scope of their representation and completely eliminate themselves from having to appeal. I think you still have responsibilities, even if you're not going to handle the appeal by contract. Generally, an attorney has to abide by their client's decisions. Like we talked about earlier, notify the client right away of the right to appeal and determine whether the appeal is desired as soon as possible. There's one case I want to hit on just very quickly. It's the JOA case from the Texas Supreme Court. That was a case where trial counsel was supposed to file a statement of issues before you could appeal. That was a jurisdictional requisite. That is no longer the law. But the point is, the appellate counsel wasn't appointed till after the deadline, and the trial counsel never filed these things. And just very quickly, the Supreme Court said trial counsel's failure to follow through with his representation until relieved of that duty was tantamount to abandoning the client at a critical stage of the proceeding. And they also characterized it as seriously deficient. So I wouldn't rely on the appellate counsel. I would make sure that you take care of the notice of appeal and the rest of the things that we talked about earlier.
Yep.
What you can appeal. Generally, you can't appeal interlocutory orders. That would be your orders following your status hearing, your adversary hearing, your permanency hearings, those types of things. However, sometimes you can mandamus those. In fact, generally, I think you can. However, it's a pretty high burden to win on mandamus. You have to show a clear abuse of discretion and no adequate remedy by appeal. Generally,
And I'm just going to add, if you don't like the removal order at the 262 stage, mandamus is quite frankly the only way you can appeal that. So if you don't mandamus the 262 order or ruling, then you're shut out from doing it at the very end of the case.
yeah. And that may be an issue as well if you're on appeal challenging an O ground, and the O ground requires a showing that the child was removed for abuse and neglect. And as I'm going to get to that in just a second, I've got a few case sites for you on that. Generally speaking, you only appeal from a final judgment. But going back to what we were saying about earlier, in Re AA in 2023, the Supreme Court said, finally, we pointed out that mother had not challenged those findings, and we cited an authority that they're talking about the ECR case, that temporary orders and suits affecting the parent-child relationship are reviewable by mandamus. As in ECR, there's no indication in the record of this case that mother's counsel challenged the order by mandamus. In fact, there's no indication that mother argued at any stage of the trial court proceedings that the factual predicate to O had not been met. So if you want to challenge that part of O, you need to consider filing a mandamus to challenge that in the trial court. That's getting a little bit more complicated. Mandamuses are something we're not going to talk about today, but if you think you're going to challenge that, you need to think about a mandamus. In layman, they explain that a judgment's final if it disposes of all the pending parties and all the claims in the record, except as necessary to carry out the decree. After a trial on the merits, the final order is presumed final. I know we've run into some problems with that, like where we forget to take care of an alleged father or that sort of thing in the decree. And technically, when we don't address somebody or something that is a party, it's not technically a final order, and the Court of Appeals will dismiss the appeal and send it back. If you're not sure whether your case is ready to be appealed, that let's say the court does an oral rendition, as they often do at the end of the trial, or you get confused. I get confused when we're dealing with de novo review by the trial court. I mean, if you get confused about the dates, file the notice of appeal. Premature notices of appeal are effective once the date passes whereby they become final. So if you're in doubt, just file it.
And they become final when you have a signed order. If there's a problem, if you notice a problem with the signed order, you can go back and you have 30 days to do a motion to correct the order. And if the court indeed does that, that starts your appellate timeline running all over again from the date of the new corrected order.
Real quickly, some critical deadlines. Notice of appeal has to be filed with the trial court within 20 days of the signed judgment, not the oral rendition, the signed judgment. Requests for findings of fact, conclusions of law, which we'll talk about in more detail below. The first filing for that is on the 20th day. Post-judgment motions are due on the 30th day after judgment, and 35 days after the judgment is the deadline for filing an extension to file a notice of appeal. Courts are, as Karen had pointed out earlier in one of our discussions, and she's right, courts are pretty lenient about that 15-day extension. But gosh, that's risky. I would
very risky.
I've only done it once, and I didn't feel comfortable doing it, and I would rather not. I'd rather file it on the 20th day and then ask for a delay in the briefing of some sort. But if for some reason you don't get noticed that you've been assigned to the case, you can file it late, and that's a good excuse. Finally, if
Yeah, you definitely need good cause though. So, because otherwise you have to say, "Dear Court of Appeals, I'm an idiot. Please let me file this late." That's bad form.
Sometimes you have to do that, fall on your sword. And lastly, if you don't get notice of a final judgment and it takes more than 20 days before you get noticed, you can actually move up to 90 days to file. I've never had to do that actually, because everything's electronic now. It's be pretty weird circumstance where you don't get notice of a final judgment. But if that happens, you have up to 90 days to act.
There you go.
Perfecting the appeal. Who appeals? The person who appeals is the party who wants to alter the judgment some way, or any other appealable order. If you're fine with the order, you don't have to file a notice of appeal, and you can still argue alternative grounds for affirming the judgment, and not have to file a notice of appeal. And the non-appealing party gets no more relief in the Court of Appeals than given by the trial court, but you can argue alternative grounds to keep that relief. On the other hand, if somebody appeals and you decide, well, since they're appealing, I didn't get everything I wanted, I want to file a notice of appeal as well. You got 14 days after that original notice of appeal, timely notice of appeal is filed. So your notice of appeal deadline can be extended if you're doing it as a cross appeal in response. The notice of appeal is jurisdictional. That's the one thing. If you come out of nothing else from this webinar, remember that. Everything else you do under the appellate rules, they may require you to fix something. You may get, a nasty letter, not nasty, but a critical letter. But there's nothing else jurisdictional in the appellate rules. Get the notice of appeal in on time.
And do not let anybody tell you, oh no, you've got 30 days. This is an accelerated appeal. You've got 20. That is it. So put that on your calendar the day that the judgment is signed. No question.
And as Karen said, they are accelerated. The notice of appeal has to be filed within 20 days after the judgment is signed. The general rule in normal civil cases is if you file a timely post-judgment motion or request for findings, then your notice of appeal deadline is extended. Not in these cases, not in accelerated cases. It's 20 days. There's nothing that's going to change that unless you move for an extension. You file the notice of appeal with the trial court because the Court of Appeals is not yet in until after that's filed. But if you mistakenly file with the Court of Appeals, again, like I said, that's okay. They'll go ahead and treat it as if you filed it with the trial court on the same day. If you're going to move for an extension of time to file the notice of appeal, you have 15 days. You file the file the notice of appeal in the trial court like you would originally, but file the extension in the Court of Appeals. They're the ones that decide whether you get an extra 15 days.
Michael, one of the things that I've done is I file the notice of appeal in the trial court, and then I do a courtesy copy at the Court of Appeals. There's actually a little choice that you can click through. I use file time, but does it matter? Is it necessary?
It used to be required, and I can't remember if it was part of the docketing statement that you had to append a file stamp copy back when they had file stamps to the Court of Appeals. That's not required anymore. And we'll see on the next slide, but there's nothing wrong with it. You're not going to get in, any sort of trouble. And I guess I've given up on doing that because we have 2 courts of appeals, and I don't know where it's going until days later. So I don't bother with it. But I mean, if you want to do that, they may appreciate that. When you serve the notice, you serve all parties, and please include the children's ad litem. Also serve the court reporter if you'll be requesting a record from them. That gives them a little heads up that they need to start on it. You can amend the notice of appeal anytime before you file your brief. That's usually not necessary. Again, if in doubt, file a notice of appeal prematurely. And this was the point, Karen. The trial court clerk's responsibility now has the responsibility to forward the notice of appeal to the Court of Appeals. I believe that's new. I think up until fairly recently, we had to append the file stamp copy to it, either the docket sheet or file it separately. I can't remember. But now that everything's electronic, they don't require that anymore.
The other thing I was going to point out on this slide, where you said send a copy to the court reporter, you know, what I've done is on the very last day of the termination trial, when it's obvious things are going to go south for your parent client, I just give my card to the court reporter and say, my client is appealing, just giving you a heads up, because they have a shorter time to prepare the entire record, the court reporters do, than we have to file the notice of appeal. So just as a courtesy to the court reporter, try and give them a heads up, even by email. Let them know that this case is going to be appealed.
Absolutely.
Sometimes you have substitute court reporters coming in. You need to notify all of them.
Yeah, it's a major pain when you have 2 or 3 reporters from the pool and trying to get all them coordinated, but it takes some work, but you have to do it if you're going to appeal.
Yep.
Okay. Perfecting the appeal. It's pretty basic. It's usually a 1-page document plus a signature block and a certificate of service, but it's just got the court, the number, the same heading that or style that you'd use for everything else. The date of the final order or judgment that you're appealing from, state that you want to appeal, state which court you're appealing to, who it is that's appealing. Make sure you say mom wants to appeal, you know, if dad doesn't, or if you can't find dad. And then make sure you point out that it's accelerated. I think most of the clerks know this sort of thing. When they see a CPS case, they know, but that should be in there too, that's required by the rules, that it's accelerated, statutorily accelerated. Importantly.
One thing I wanted to, oh, sorry, go ahead.
No, please.
Yeah. The Texas Rules of Appellate Procedure is, if you need help with your first appeal, this is a Bible, y'all. It really goes through everything that you need to do. It sets out exactly what is required for the notice of appeal and for briefing and other things. So definitely do not forget to go to the Texas Rules of Appellate Procedure. And then depending on your county, go to your Court of Appeals website, like Travis is the 3rd, and Beaumont is the 9th, I think. Anyway, those websites will have a list that says local rules and forms, and see if you have local rules, because they might be requesting something in addition to Texas Rules of Appellate Procedure.
And I'm not going to do this for all our samples, but you can see this is pretty much a notice of appeal. There's not much to it. 1st or 14th, it's accelerated. It's within 20 days of the final judgment, and we're exempt from paying fees because she's indigent. Oh, that's something else that, you know, that you ought to probably attach. You can attach your notice of appeal is if you're indigent. Again, we've had issues where the clerk, you know, holds up because it doesn't happen often, but when you request the reporter's record, the clerk's record, or file a notice of appeal, if you have a copy of the order finding indigency, it's not a bad idea just to attach it. Save yourself a little bit of heartache later. Post-judgment preservation. Generally, if you don't preserve it in the trial court, it's gone. There's a few exceptions. You can raise subject matter and personal jurisdiction anytime in any of the courts for the first time or second time or whenever. Usually a motion for new trial is not required to preserve anything. You can file one. It's not a bad idea. It's a way to kind of get your arguments together. It's a way to give the court an opportunity to reconsider its judgment, but it doesn't give you more time for the notice of appeal. And but it's not required in most cases. There's a few exceptions. Generally, you need a motion for new trial, jury misconduct, newly discovered evidence, incurable jury argument. But following a jury trial, the only way to preserve factual insufficiency or against the overwhelming weight of the evidence is through a motion for new trial. So you have to file it after a jury trial if you think you're going to argue a factual sufficiency ground on appeal. If not, you waive it. One thing to bear in mind, if you ask for relief in a motion for a new trial, you're only going to get a new trial. So if you, I'll show on the next slide, the way to preserve a legal sufficiency challenge. Why don't we do that? And
yeah, let's do that. That helps you win right off the bat, legal sufficiency.
You can move for judgment notwithstanding the verdict. More commonly, a motion to modify is something I use a lot. I call it the Swiss Army knife of post-judgment motions. Anything you don't like that went on below, you can probably raise in a motion to modify. Again, lots of cases in Texas law that say form doesn't matter as much as substance. Don't worry about form, just, but for legal insufficiency or matter of law issues following a jury trial, there's a bunch of ways to preserve it. Motion for directed verdict, object to the submission of a jury question because there's, legally insufficient evidence, motion for JNOV. You can also preserve that through a motion for new trial. However, if you win that point, you get a new trial instead of a rendition. Normally, a legal insufficiency challenge is a rendition point. In other words, you just win and there's no new trial. However, if you raise that point in a motion for a new trial, you get a new trial. So you're not putting your client in his or her best position when you do that.
But factual insufficiency sometimes does get you back there. So
yeah, it should be a remand point, factual insufficiency. But and that we'll kind of talk about this a little later if we get to it, but you want to raise those rendition points first. The court should address rendition points first. In other words, something they can render a judgment on as opposed to remand for new issues. So they will usually address legal insufficiency first. Although if you've done these sort of appeals or read the cases, you see the courts don't know with the clear and convincing standard, and they don't normally distinguish between the two. It's a little sloppier than the normal civil cases, but that's another issue.
We'll email you about that after.
I keep saying I'm gonna write a law review article on it, but it's probably never going to happen. You can do some of these motions orally. They've got to be on the record. I prefer written motions. I prefer to do it because I can actually make my thoughts clear and put my authority in. I don't skip anything. Also, I'm sure it's actually on the record. When you're doing a post-judgment motion or any motion, do an introduction, tell the court what you want. Review any relevant procedure, history, facts, that sort of thing. Then tell the court why you deserve relief. That would be your argument and authorities. And then conclude and tell the court what relief you want. And I guess my point is, courts look at substance over form. So don't panic if you don't have a form. We've had attorneys in my office that come in and say, I need a motion to modify a judgment, and they have a real specific thing. And I'm like, yeah, just type something up that says that. And no, I need a form. And they'll spend hours looking for somebody who's done that before. And I don't really understand that. That hasn't happened a lot, but it just your form doesn't matter. It's the substance.
Exactly.
Timing. Do you want to cover this one, Karen?
No, I was just noting that we are about halfway through in terms of our timing.
Yeah,
so,
we're behind, aren't we?
Yeah, we want to get through our post-judgment motions because this is a very rich PowerPoint, but you guys need to remember the trial court's plenary power ends 30 days after the judgment or 30 days after the post-judgment motion was denied. So just keep in mind that you have a very narrow window to move to modify the judgment, which gets you more time in the appellate end of things. It is available. Sometimes it's technical. Look at the other Bible that you have is Texas Rules of Civil Procedure. Definitely go back to that. I flip through that all the time.
If the court modifies the judgment in some way, your deadline for notice of appeal starts anew. Just a tip here is,
Uh,
though, don't assume that they'll modify. Even if you think you have the most meritorious point that's ever, file your notice of appeal. I can't say it. I can't stress that enough. And if the trial court ends up giving you the relief you want, just dismiss the appeal. But if the trial court does not modify, you've missed your deadline. So don't do that. And again, under normal civil cases, post-judgment motions and requests for findings, extend the time to file a notice of appeal, but not in these cases, not the accelerated cases, 20 days, 20 days, 20 days. And generally speaking, the original notice of appeal will cover any changes to the judgment by the trial court. So if the court does modify some part of the judgment, you don't necessarily have to file an amended notice of appeal, but you can. The rules permit it. Findings of fact, generally, we don't really have to worry about findings of fact because Rule 306 says that the findings should be in the judgment for a termination suit or a conservatorship suit brought by the government. The only time you'll
Thank
want to,
goodness.
excuse me,
Thank goodness, because this was always really confusing for me.
there's so many statutory findings. The code requires so much stuff. I mean, it's really got to be this way. I'm guessing that's why they created the rule. And findings are pretty much only needed after a bench trial, not a jury trial. In a jury trial, your findings are the findings made by the jury. If the court is missing findings, if you think there's a finding that ought to be in there, or if one finding is wrong, whatever the case may be, you can address that two ways. Number one, you can file your request for findings of fact, amended findings of fact, conclusions of law, or for additional findings of fact. And at the same time, what I would do is file a motion to modify, as the case may be. But I would do both. If so, once you get your judgment, review it to make sure the findings are actually, because we make mistakes. The department actually does these things. It's all on hot docs, and sometimes the wrong thing comes out. And point that out, and we'll get it fixed. Yeah, we got to move a little bit faster here. Reading the appeal. There's docket statements. You have to complete a docket statement. Upon filing, you must promptly file a docketing statement. The type of stuff that it's in it are the parties in the trial court, contact info, relevant dates. Did you make the request for the record? The type of case. Is it accelerated? Is the client indigent or the appellant indigent? Mediation. Do you want to go to mediation? It's not jurisdictional. The forms are on texascourts.gov. And once you get to that site, go to your particular court. And as Karen mentioned earlier, there's a bunch of forms. Most people don't file docketing statements these days. And the court doesn't.
What?
Yeah, at least not in Houston.
Seriously?
No.
Oh my gosh. In the third, we get serious notes from the court. Hello, file your docketing statement.
I wish
along those, I was just going to tell you, docketing statements, to properly fill them out, I think those take me close to an hour to do properly.
I think that's.
And if you have questions, call the court clerk. I mean, Jeff Kyle at the third court is really, he and all of his staff are really good about helping you with, if this is a new appeal and you haven't done them before, they'll walk you through it. They're just really wonderful people over there.
Next thing you have to do is you have to request a clerk's record. Here in Houston, anyway, the clerk goes ahead and just completes a record. Whether you ask or not. I just got one that's like 1,700 pages. They basically included every document. So that's one of the downsides of not requesting a clerk's record, and the clerk just does whatever. But what has to be in there are the live pleadings, the verdict, findings of fact, the judgment being appealed, request for finding if you're wanting to appeal that, post-judgment motions, notice of appeal. This is all in the rule.
Cool.
You can include other things if you want, if you think you're going to need them. You probably need the orders from the statutory hearings. You can request, even if the time has run, you can still request. You can request to supplement the record at any point. because inevitably when you get these massive dumps from the clerk's office, there's things that are missing, typically the statutory hearings. There's a part in the rule. We have a problem when we have video or audio that's on a separate, like a thumb drive or whatever. They don't really have a process for storing that. We've had it where courts basically take the thumb drive and like put it in a desk drawer or something. And that creates a problem. And the rule addresses that, Rule 34.5. So if you have that issue, the parties can get together and basically agree to what's missing from the record and replace it. And this, when you see little boxes that are surrounded by red, you can double click on those when you get the PowerPoint, and that'll open up to the full form. That's an 8-page form in there, and it shows my request for a clerk's record. It also shows my request for a supplemental clerk's record. It's too much to put on the actual page here, but when you get the PowerPoint, double click on it and you'll see it. Reporter's record is similar. You can designate what you want or what you don't want. You're supposed to request it in writing, what parts to include. It's probably a good idea to also tell the court reporter what you don't want, because we've had reporters including things that, like pretrial hearings, that sort of stuff, status hearings or statutory hearings. Well, that's not part of the appeal, and it's just a waste of the court reporter's time. And so you can include that too. Again, if you missed the deadline for requesting it, you can still request it. The rules are very forgiving. Traps are very forgiving. If you only request a partial record, I should have a cite to the rule there, but it's going to be in Rule 34. I'm sure of that. You have to include a list of points or issues that you're going to raise. So that way, if the other side says, well, we're going to need this day, you say we don't, but we're going to need this day. So they have a chance to object to that missing part of the reporter's record. But if you go through this process, the court will assume that the partial record is the complete record to address the points and issues. If you don't go through this process and don't send up the full reporter's record, the court will assume the missing stuff includes the evidence that supports the court's findings. So make sure you follow this process. Typically in a jury trial, I wouldn't include open and closing voir dire, but I would follow this process up here to make sure the other side, even though there's no evidence in these things, I still follow that rule. Again, the box, you can click on it and see how I request the reporter's record. Again, they've got to get the records up there, the clerk and the reporter, within 10 days. The court can extend it. They have to move for an extension if they need extra time, not you. If you take care of your responsibilities of requesting the record, and if needed to pay for the record or arrange for payment, it's out of your hands. It's all between the court and the clerk and the reporter now. It's no longer your problem. That's all that's saying. So take care of it up front. It's really not your problem. If you fail to get the record up there, if you fail to get the clerk's record up there, the court won't go forth with the appeal. If you fail to get the reporter's record, the court will go forth with the appeal. But again, they assume that the evidence missing is evidence that supports the court's findings. So you better hope you have a legal issue to get it reversed. If you're the appellant, or, you should file a notice of designation of new counsel. And the reason you do that is because you want to get into the portal. You want to have access to the portal. That's where you get copies of the record. It also gets you on the court's list so you get notices of the courts, when they send out a letter or a motion or an order or that kind of thing. You want to get your name on there. And you also the trial attorneys usually want to get their names off of there, because the court begins with basically who's the lead counsel at trial. That's who they put in there originally.
For the super newbies, you really want to use the attorney portal to go on there. They will have the clerk's record and the reporter's record there. Download from that portal, because every reference that is going to be made in your brief is going to refer to what is in the appellate record. If you don't make that reference, that can cause a lot of problems with your briefing. So you have to say, for example, volume 2, page 7, mother completed all of her services, and you make the reference to the reporter's record where the caseworker testified to that. So get it off the attorney portal. It's super handy.
We're going to skip the standards of review. They're in here if you want to take a look at them. These are the general standards of review. Let's get into drafting the brief. You have 20 days after the records get up there. We only have 20 minutes left, Karen. You have 20 days after the
Yep.
record gets up there to file your appellant's brief. The appellee has 20 days after that. And if you want to file a reply brief, again, 20 days. You can extend these deadlines, and people frequently do. You have to file the briefs and motions with the appellate clerk electronically these days, with some exceptions, and you have to serve everybody. Pretty straightforward. You can use electronic signatures, 8.5 by 11, 1-inch margins, double spaced text, except for footnotes, block quotes, that sort of thing. And I frequently use in my briefs basically columns or boxes. And like when I'm doing drug testing information, I put it all in a box, and it's easier to get to, and that comes out of the double space sort of thing, but it's a lot easier to read. You have to include an appendix, and if you're electronic, you have to bookmark between the appendix and the documents, so the court can, a lot of these, I'll mention this a little bit later, but many of the judges read these briefs, on pads or tablets or laptops, and so they want it kind of easy where they can jump back and forth between things because they have so many to read, which is very reasonable. 14
Actually,
I'm sorry.
bookmarks are required. They're actually required. And
Right.
it has to open to bookmark view so that they can click to that really fast. And again, look at your local rules in addition to the Texas Rules of Appellate Procedure to be using that. And I cannot stress enough, Adobe Acrobat is your friend. Word and Adobe Acrobat will help you write your briefs and automatically populate the appendix and the table of authorities.
There are some less expensive PDF editors out there. Adobe's kind of expensive, but it is the best, that's for sure. 14-point text, 12-point footnotes. I can't read 12 points, so I use 13. 15,000 words for your principal briefs, 7,500 for your reply briefs, 27,000 total for you. That's a lot of words. And they don't count part of the brief in the page counts. Basically, everything up to your statement of facts is not counted in your word count, and everything after your prayer is not counted. So it's just the meat of the brief that is counted. And as Karen said, get a good PDF editing program. If you can afford Adobe, that's the one to get. But
mine's only $20 a month.
Oh, really?
Just, yeah. But I only, there's only 2 of us.
You got to use aliases or pseudonyms in parental termination cases generally. The rules only require that minors be identified with aliases, and it says the court can order parents to be identified that way. And documents that you file with it, in the appendix or whatever, they have to be redacted to reflect that. I use mother and father for mother and father. It just seems easier to find things, instead of their names. Right in the beginning, I put down, ABC equals mother, DEF equals father, and that's what I call them. It gets more complicated when there's 3 or 4 fathers. I use them.
Yeah, but it also humanizes them. Don't forget, these cases are about real people, real families, parents and children. So I agree with you. I always try to use mother and father or uncle or whoever.
Right.
Yeah.
I do the same thing, grandma, uncle. Again, sometimes it gets a little bit more complicated if there's 2 or 3 of them, and children, I usually try to keep the same. Like if the child is DEF is the initials, I'll call them Darwin or Delora. I don't know, whatever it is, try to keep it that way. Of course, there's some families where 6 kids all named with a J. It gets a little bit more complicated. I actually include in the front of my brief a legend of pseudonyms. So if the court gets as confused as I am, sometimes they can jump back and forth to that and see what it looks like. Let's go with the cover page. There's not much. The primary thing that you want to talk about on the cover page is you've got to put on the front, besides all this basic information, you got to put whether you want oral argument or not. If you don't put that there, it's assumed you waived it. The court may still order you to oral argument, but oral arguments are so rare these days, that's probably not going to happen. But the point is, you've got to put that on the front. That's part of, um, that's probably the most important thing on the front. The other thing is you've got your identity of parties and counsel. That's a fairly new requirement. You got to have the trial counsel for all the different parties, including the ad litems, certain contact information. Again, I use a box. It just keeps
And
everything.
it's beautiful.
Well, thank you.
I cannot tell you, having looked at so many briefs, and I don't look at that many compared to the clerks who receives them. This stands out. It's fabulous.
Well, we were talking about this yesterday, you, me, and Renee, Karen, and Renee, I think it was just, what do I do to make my brief stand out? And I actually formatting, stuff like that, headings, lots and lots. I'll show an example in just a minute. I use lots of headings, and I want my brief to be easy to read. And when the court needs a reference brief, like it's looking for certain facts or whatever, I want it to go to my brief. And so that's my thought process. It takes a little bit more time, but I think it's easier. And table of contents, you'll see that, again, use lots of, in my statement of facts, you see everything's subheaded. I mean, on page 4, I've got 3 different headings. But if the court's looking for something, was there a notice of jury trial? It's right there on page 4. It's easy to find. And,
Great.
I don't want to go through all these, but it's the same for all these. In my arguments, I got everything broken down into subsections, and when I repeat the issue, I put the full issue in there. I've actually been to seminars where some justices say that, a lot of them don't start on page 1 and just start going through one by one. Some say they go to the table of contents first and kind of get a lay of the land, just a big, broad, big picture view of what's going on. Others go straight to the summary of the argument. Others look at the statement of the case first because they want to figure out, and we'll get to those in just a minute, but you've got to have a table of authorities. We'll skip that, but I break it down into types of things we have. I do my cases first, alphabetize them. Then I do the Constitution and the statutes and the rules. If I have secondary sources, they'll go under the rules. Statement of the case.
I've rarely used secondary sources. Very rarely.
Pretty rare, especially in family law. When I was doing some other stuff, I would use it more. But statement of the case. There are 2 types of statements of the case that people use. This is kind of the narrative view, where you usually a page or 2, and you go into a little bit more detail. This is kind of the newer, more preferred view, a very, this is the way, if you do a petition for review, this is the way the Supreme Court likes it. Very to the point type thing. Either there's no right or wrong, but the idea is to put in basically what's happened in the case, how it got there, what happened. No factual discussion. It's just about the procedure of the case. You've got to include a statement regarding oral argument. Not only do you have to have something on the first page, but in your brief, you have to include a statement regarding oral argument. You'll see most of the time I say that the briefs take care of it. It's well presented in the brief and the record. The department doesn't believe the decisional process would be significantly aided by oral argument. However, if you grant it, we'll be there. That's usually what I include. Sometimes I want oral argument. A reason to have oral argument, I guess. Novel legal issue. If there's courts of appeals with conflicts, sometimes the 1st and 14th especially go different ways, and it's kind of the luck of the draw, which court you're in, which rule you have to follow. Novel factual situations. In other words, the cases that are out there are distinguishable. And the courts, I've heard many justices say, if you're interested in board certification, let us know. We'll give you oral arguments, because I think you have to have 12 for that. So another reason to do it. Okay, you got to have your issues presented. That's all straightforward. Your issues should be kind of descriptive. The court's removal of the case from the jury docket was error since the interveners filed a timely jury demand and paid the jury fee, since mother relied on the intervener's jury demand, and since mother timely objected to the district court's removal. I mean, it's pretty descriptive. They can figure out what's going to go on in there. And that's one of my points here. Within reason.
This is a question I had. So if a parent is terminated on the usual, let's say D, E, N, and O, or D, E, O, and P, do we put 4 different issues plus best interests?
Yes, I would. Yes.
Yes.
And,
Okay.
and that's one of the things now you have. In the old days, it was points, and now it's issues are favored. And an issue, it covers every subsidiary question. So if you're doing an O issue and you've got maybe an evidentiary issue that this shouldn't have been admitted to show, you know, that he didn't complete the psychological, that was hearsay, the psych report or whatever it is. You can put that sub issue inside the O issue, that in the old days that would be called a multifarious point and they would ignore it. But now you can have broad issues, but I would definitely separate D from E, from O, from P, and best interest, just from organizational point of view, if nothing else.
Great.
Okay, and the statement of facts, first thing, no argument, period. It's for the statement of facts only. Most every sentence should have a record citation after it. And if the appellant does a good job of the statement of facts, you're free as the appellee to say, good enough with me, or I agree, I've done this. I agree with the first 6 pages, but page 7 through 9, I don't agree with, and here's my statement for that, for talking about whatever that specific event is. So you've got some freedom there too as the appellee. But let me show you one thing. Karen was talking earlier about the citation, and see, when I cite the clerk's record, CR 96, I'm looking for something for the reporter's record. There may not be a reporter's record in this one. I've got a supplemental record, so I put in front of there, second clerk's record, supplement, and then the page number. If you do it like first volume, clerk's record, then a page, and they're all separate things, that counts as 4 words. And since I'm wordy, I want to try to preserve all the space I can for all my brilliant legal arguments. But again, I've got sub issues that I don't even have in the heading, sub issues everywhere. They're reading this on tablets. I want them to be able to get around very quickly. Lots of headings. Summary of the argument should usually be a page or 2. Don't just repeat your issues, the issues on appeal that you've listed elsewhere. As I noted earlier, some justices read this very first, so it is important. I'll be honest, sometimes it's an afterthought for me when I'm 8 o'clock trying to get a brief done and I'm just kind of winging it, but that's probably not a good idea. But the rule says succinct, clear, and accurate statement of the arguments. So this one's a 2-pager. And again, clear and concise arguments for contentions made. You have to cite to your authority and to the record when you're doing the argument and authorities. Include a standard of review. If you're doing, like Karen suggested earlier, you've got all factual and legal sufficiency points from multiple findings in a termination case. You could put one standard of review right at the top. That's what I do, right on top of all the separate issues. On the other hand, if you've got one issue that's a factual sufficiency review, you got another that's an evidentiary review, you got another that's ineffective assistance, I would put a separate standard review in each one of those issues. So whatever you're comfortable with, but you do need to include a standard review.
We have about 5 minutes.
Yeah.
I know.
And the prayer, this is important to me because I've again heard justices complain about this. When you do your prayer, you need to be specific exactly what it is you want, and put something alternatively. The first request is, I don't know what's in this one. Let me see. For the reasons set forth above, the department respectfully requests the court to reverse the final judgment of the district court and remand this case for a new trial before a jury. If the court determines that the district court's denial of a jury trial was not reversible error, then the department requests the court to affirm the judgment and all of us. Oh, that was one where we didn't mind the judgment. But the point is, feel free to do alternative relief. This is actually an issue I've seen come up in oral argument too. Justices will say, what is it you want in this case? And sometimes the attorneys will kind of stutter because it's very simple, but you didn't put it in your brief. And so, think about that. Again, your prayers shouldn't be an afterthought. Certificate of compliance for your 15,000 words. You can take a look at that later. Any of these things I've got over here, when you get the PowerPoint, just double click on it. It'll open up in your PDF viewer. The appendix, certain things have to be in the appendix. You can put other stuff, but you cannot use the appendix to avoid page limits or word count limits. And again, as Karen mentioned earlier, the rules require you have bookmarks to the appendix. Appley's brief.
I was going to say, you're not required to put in your appendix every case that you cite in your brief. If it's brand new or it hasn't made it to, the regular, off of Westlaw, I guess maybe you can do that if it's super on point, but don't attach every single case.
No, attach. Like if there's something from the Supreme Court that's, everybody knows it, I probably wouldn't attach that. But if there's something obscure from Amarillo that, is unpublished and it's going to take them a little bit of work to find it, maybe I'll attach that. As far as like statutes and rules, unless that's a specific, the case turns on the statute or rule, I'm not including any of that either. It's just a waste of space and they're not going to look at it. Appley's brief, everything's the same, but if you're satisfied with the parties in counsel, the statement of the case, the statement of the issues, the statement of the facts, you do not have to include that. You don't have to have an appendix unless you're adding something more. This is important. You can always point to other people's brief and say, the argument he wrote in here is exactly what I like, so I'm adopting it in mind, and not have to basically reinvent the wheel every time. Doesn't happen all the time, but it's kind of cool. Everything's construed liberally in the rules, but sometimes they'll send things back, especially if you're off on pagination, page numbering, margin, stuff like that. They'll send it back and tell you to redo it. Advocacy tips. This is something we could both talk about here. As I mentioned, justices do not always read briefs seriatim, so use lots of introductions and conclusions in each argument, sub-argument, that sort of thing. Use very descriptive headings. You can have a little bit of persuasion in the headings. Don't get carried away, but always make sure you stay within the record. We do have problems sometimes with counsel going outside the record. Pretty much every factual statement you make should be followed by a citation to the record. Please don't copy other people's briefs verbatim. I've seen where people get in my ABA newsletter where other people have been disciplined for that. Plus, it's just bad form.
I've done that, but I've called the author and asked permission and given them credit. For example, with Disability Rights does really amazing briefing, and I've called them to ask permission to quote their brief when I had a disability issue come up.
Yeah, exactly right. And if nothing else, attribution, put it in a block quote and, say where you got it from. At least then it's not plagiarism. It's make sure you're organized. It's so much easier to follow for the judge if it's just not a stream of consciousness thing. Write in clear, direct sentences. Use the active voice, not the passive voice. Don't denigrate opposing counsel or the courts or any of that sort of thing. Attribute to them ulterior motives for doing whatever they did. You'd be surprised how often that pops up. Don't ignore precedent. If you got a bad case, try to distinguish it. And again, if you're making an argument without any sort of record sites or authority, I will argue waiver. I don't like doing it because some of my opposing counsel are friends, but I will. Anything to add, Karen?
I was just going to say these are great tips.
Oh.
And Michael is one of the smartest people I know in terms of appellate work. So I really appreciate you.
That's very nice. But Renee, cut her off.
Well, thank you all both for that wonderful presentation. I know there were a couple more slides that y'all did not get to go through, but they will be available in the PDF, a version that we will make available online. And so on behalf of the Children's Commission, I do want to thank both Karen and Michael for their time and for this very informative presentation. I encourage all of you to email any questions submitted through the Q&A feature that were not able to be answered during this live presentation directly to Karen and Michael for response. I do believe Michael has their email addresses available on the final slide. The State Bar has approved this course for 1 hour of MCLE credit. Individuals who are watching this replay may contact cctraining@txcourts.gov for the MCLE self-report information. Once again, I want to thank all of you for joining us for this presentation, and we hope you have a wonderful rest of your day.